I'm a clinical professor here at the law school and the faculty director of our Tech and Platforms Initiative at Silicon Flatirons. I'm delighted to be turning to the closing panel before our final keynote of the day, which is focused on legislative and regulatory priorities to codify trust. And to talk us through the topic, we've got a great array of panelists, and I'll refer you to their full bios in the program, but just by way of introduction, Jesse Blumenthal, who's the Vice President of Technology Innovation at Stand Together and the Charles Koch Institute, Dirk Hensel, who's the Head of Communications and Executive Office of the Federal Commissioner for Data Protection and Freedom Information in Germany. We've got Marianela Lopez Galdos, who is the Global Competition and Regulatory Counsel at CCIA, Gabrielle Rejois, who is the Senior Policy Manager of Color of Change, and Jeff Turner, who is a partner at Squire Patton Boggs. So just to tee us up here, when I was planning for this panel and starting to get the moderation together, I asked Amy Stepanovich, our executive director, what is this panel about? What's the scope of what we mean when we talk about legislation that's addressed at trust? And I said, are we talking about privacy and data protection? She said, yep. And when I said, well, what about algorithmic accountability? That too. Maybe about Section 230 and thinking about content moderation, the trust dimension of that. Yep. What about antitrust? I know it's got anti in the name, it's antitrust, but does that have something to do with the level of trust that we have in companies? Yep, that too. What about civil rights law? Indeed, that as well. During the conference, I've heard brought up cybersecurity, broadband deployment, net neutrality. I'm pretty sure we didn't get too deep in the weeds on intellectual property, but we'll cut this out. So we have got a big task to go through today. We've got a lot of potential areas to talk about. And by the way, we want to do it not just focused on here in Colorado, not just focused on the US, but think about it internationally as well. But I'm delighted that we've got a great panel to talk us through this. Where I actually want to start is a provocation that one of our panelists gave us as we were prepping for this, which is, let's talk about high and low politics and the high and low politics of trust. And Jesse Blumenthal asked the question, can tech legislation and regulation be boring again? Can it be technocratic again, or is it going to be consumed with politics? So before we get into each of these kind of specific areas, at a high level, what are these debates going to look like? Are we going to see the high profile political fights that we've seen over things like net neutrality in Section 230? Or are we going to see a return to more technocratic debates? So, Jesse, I want to start with you to tee up your thoughts about this topic. And then, kind of by way of introduction to the rest of the panel, I'll turn to folks in turn to talk about how they see this high and low politics divide materializing across their areas of interest. Jesse, go ahead.
Blake, thank you, and thanks, Amy, and everyone at Silicon Flatirons for the last two and a half days. I'm glad you started this framing, not just because I suggested it, but because it's been an idea that Dan Rothschild at the Mercatus Center and Jerry Brito from the Coin Center talked about a couple of months ago, and that has been sort of nagging at me ever since. And when yesterday during the debate, when Paul Ohm said that we should leverage the distrust to fuel the political will, I think he captured what I would call, or what they would call, high politics in a nutshell, right? And that is tech as culture war. Tech as the thing on the front page news, tech as the thing that politicians talk about in stump speeches and fundraising emails, and you can contrast that with the boring technocratic, I would say more substantive and more grounded, low policy debates that were previously maybe more common. So, let me maybe offer two examples of the long list you offered and why I think we're sort of at least for the foreseeable future, stuck in the realm of culture war tech policy. And so the two examples I'll pick up on are Section 230 and antitrust. Section 230 used to be largely unknown, right? It was this sort of background law that held users responsible for their actions online and allowed hosts of user-generated content to set rules appropriate for their communities. And in the past number of years, we've seen this sort of entire transition, right? So it's not just shocking that the president of the United States or the then president of the United States is tweeting about Section 230 more than 40 times, but it's become this sort of shorthand for I don't like things on the internet, therefore Section 230 is the problem. And oftentimes the things people don't like are First Amendment protected speech or choices that others make that they disagree with. And I think you see a similar sort of shift in antitrust, right? The aborted presidential campaign of Elizabeth Warren was in many ways centered on this idea that bigness is bad and everyone who's big is a monopolist, and the government needs to come in and dictate terms. And so, I think we're stuck, at least for the foreseeable future, in this realm of tech as culture war issue because of the way incentives align, right? So if you're a political leader and you can make people angry, make people tribal, portray these types of issues as us versus them, then it doesn't really matter that the thing you're saying is Section 230 isn't actually tethered to what the statute says. You see this in not just among political leaders, but if you look at the media that covers tech debates, or if you look at activist groups that are involved here, there is an increasing positive feedback loop for them. More attention, more emails, more headlines, more spotlight for a debate that is increasingly sort of untethered from the underlying reality. So, I'd love to talk about how we could get back to a sort of boring, low policy of tech policy, but I don't think it's super likely.
Well, thanks, Jesse. That's a great place to start us off. Marianela, since Jesse teed up antitrust and competition policy as part of that discussion, turn to you next, and then perhaps turn to Gabrielle, and then bring in Jeff and Dirk to talk about how this manifests in privacy and data protection. Marianela.
Thank you so much. And first of all, let me thank you for the invite. It's great to be here, and I've enjoyed a lot the last 2 days. I've learned a lot, a lot of food for thought. And well, I think I kind of agree with Jesse. I do want to bring some positive thought to this very complicated question, which is, I think in the US, we might see a shift and have an opportunity to discuss at least regulatory initiatives affecting tech from a more technical perspective. I think there's going to be a lot of noise and a lot of extremists on both of the sides are going to keep trying to feed discussions that don't necessarily reflect reality. For example, there was a Morning Consult poll that said 5 of the most loved brands were tech companies, and one of the metrics they used was trust. There is polls that say that consumers like tech, and this is not because, I mean, don't get me wrong, I'm not saying we shouldn't do anything on the antitrust front. We shouldn't. I think having discussions, and probably Senator Klobuchar's proposal, which I agree with some parts, but not necessarily with others, sets a good start to have like technical discussions on what is best for American consumers. So I think in the US, we have an opportunity. We have different views. Again, I don't necessarily agree with the proposal, but I'm looking forward to discussing with them. I think it's a completely different proposal from, for example, what we saw coming out of the House Judiciary Report, which was a whole many of things to do all kind of things. What I like about the US is that the authorities and the regulators haven't fallen into the trap of racing to see who gets the first regulation in place first, and are trying to understand better what is best for American consumers. Unfortunately, I cannot say the same about other jurisdictions. We see in Australia some initiatives that have been put forward that I think they necessarily respond to political interests rather than technical issues. And I do not agree with that process. And I don't see that changing because they don't have an industry and not to protect, but to foster. And Europe is different. I would say that in Europe, for example, antitrust has not always been about consumer welfare, but there are also other objectives to pursue, like integrating the market. So the European proposals have to be analyzed within the context of Europe, which might also have some other political goals. As I say, there's a European Union to create. So I feel more positive about the US, but not necessarily so about other jurisdictions.
So, Marianela, before we leave you, and I think we'll get into, after we go through this first round, some of the details of the proposals that you raised, the report, the House Antitrust Subcommittee report, the recent proposal from Senator Klobuchar, some of the various things that are happening in other jurisdictions. But I wanted to ask about the dynamic that Jesse raised. It sounds like you perceive what's going on in these discussions being fairly technocratic, fairly kind of down in the weeds of competition policy. Does that sound right? Or do you think there's something to Jesse's provocation that that antitrust discussions are getting wrapped up into more political maelstroms? In other words, the sort of big is bad and all of that sort of thing. How do you see the sort of political salience of antitrust conversations?
I think we come from a period where politics has monopolized, if you want to say it that way, the technical discussions, but we might see an inflex point right now where we really care about consumers and what is best and how we can find the right balance between promoting innovation. The US has an excellent tech sector, but making sure markets work well for consumers and that consumers trust authorities, that authorities have the right resources to do what they have to do and achieve their goals. Because I think one of the most important things is that without sound institutions and law to gain goals, consumers are not going to trust the market economy. But who knows what's going to happen in the next years, but I do hope that we will move from politics to policy and to really care about what's best for consumers.
All right. On that note, Gabrielle, turning to you on this transition from politics to policy, or this fulcrum between politics and policy, where do you see the sort of civil rights dimensions of all of the legislative and regulatory initiatives that we've discussed around trust over the course of this conference? Where do you see those kind of fitting on this politics and policy scale?
Yeah, and first, I also want to echo thanks to Amy and to the Silicon Flatirons for inviting me to speak. Really quickly, I'm the Senior Policy Manager at Color of Change. Color of Change is the largest online racial justice organization in the nation with over 7 million members. And for us, we see that instilling trust in tech policy requires addressing the ways that data and technology have either left behind historically marginalized communities or have actively discriminated against them. And so when we look at privacy legislation, we want something that prohibits discriminatory uses of data. It stops the surveillance of these communities so then that these companies don't have access to data and then to abuse the data that they have access to. And thinking about like antitrust, that means creating more economic opportunity for Black small business owners and other minority business owners. And so shifting the view, not necessarily, shifting the view in the way that Marianela said, to make sure that we're protecting consumers, we're protecting workers, we're protecting folks who may not have access to the market because of different circumstances that they experience and things of that nature. I do want to touch on what Jesse said as well. And to say that, like, you know, maybe we don't want tech policy to be boring again, but we do want it to be accessible. So that way folks understand this is an issue I'm facing and here's the policies that will then like flip the lever to make it to cause the issue to go away.
So if I can follow up real quick, Gabrielle, before we move on. So when you talk about policy becoming more accessible, What's an example of what that looks like to you? In other words, are the conversations that we're having now about some of these topics, whether it's Section 230 or antitrust or privacy legislation, being driven by outside of the Beltway political conversations? Do you think that helps bring the dimensions of civil rights that Color of Change is concerned about into the conversation, or do you think that it leaves people out? How do you see that dynamic unfolding?
Yeah, so that dynamic, the way that dynamic unfolds is using words that normal folks, your average Joe doesn't use in normal conversation. So when you think about a word like algorithms, somebody might not understand that an algorithm is what helps them find a search, like find the fastest search term or find something that's actually what they're looking for. One example that I love to use is that folks in my generation often talk about how their phone is listening to them. They may be talking about going to a trip to Paris with friends. And when they go on to Instagram, that they'll see ads then for hotels or flights to Paris, when in reality, talking about like, no, this is an issue of data privacy where there are cookies that are following you across the web, and that is being fed into an algorithm that's then predicting what ad you might click on and drives engagement. So things of that nature where we're breaking down issues that folks understand and are seeing, and then connecting it to, hey, you're concerned about ads on Instagram, you may be interested in a privacy bill, or you might be interested in some algorithmic accountability bills, things of that nature.
Perfect. So, Jeff, I want to turn to you. So you've been watching these dynamics play out in the context of the federal and state privacy legislation efforts here in the United States, which have now been going on for many years or many decades, or maybe even longer than that, depending on how you want to frame it. How do you see these dynamics between politics and policy playing out in those discussions?
Sure. I will say, to put it in context, the debate has been underway for quite a while. When we first began, we were lobbying on the Hill for a little company from Northern Virginia that had 3 letters in its name, as opposed to an agency with 3 letters. And this was all prior to 9/11. And the debate then was opt-in or opt-out. And after 9/11, nobody cared about privacy. All they cared about is security. And we've now moved, the pendulum has swung back, the pendulum to the point at which privacy is front and center before the Congress. I agree with Jesse that some of these issues are highly politicized, will remain highly politicized, but I see them on a continuum. Section 230 is going to be probably not resolved this year or next, because it is going to be a cultural fight in the way in which he described it. This is going to be politics at its most extreme, because people may know nothing about 230, but they have very definite views about how platforms have been used by particular parties, interest groups, and others. I think antitrust, less so. This is a Klobuchar bill, for example. I can imagine if it had been introduced by some other senators, it would be a more political bill. I think it's a very serious effort at reform. And I think it will therefore be discussed with a lot lower temperature. And finally, I think privacy legislation is the one that can actually get done, and we can talk about it later. And I think that's going to be a very straightforward debate. Again, because as I said, we've moved from security to privacy. We've been at this for 20 some years. There are only 2 issues to be resolved, frankly: private right of action and preemption. And when you solve those issues, there's the rest, I don't want to be crass about it, but the rest are details. They can be worked out. They will be worked out in a very bipartisan tone, effort. But we can talk more about that in a moment. So I just want to make the point that these issues are on a continuum, from privacy being the most straightforward in terms of bipartisan approach, low temperature, up to 230. You can add some more subjects like net neutrality that will be up close to 230. But I'll stop there and turn it over to Dirk.
Well, and thanks for foreshadowing. And just so folks don't think we're going to drop all these interesting threads and then not pick them up later. My plan once we wrap up here is to march through, I think, each of these areas, and we'll spend 10 or 15 minutes on each one and talk about the specific proposals that are lurking out there, and how these particular dynamics are gonna play out. But before we do that, Dirk, want to turn to you. So obviously the American political and policy experience over the last 4 years has been somewhat of a whirlwind. But meanwhile, Europe has been toiling away at its own set of initiatives around all of these issues, around platform accountability and responsibility, around privacy, around data protection, cybersecurity, and so on and so forth. What's your view from the other side of the pond?
Well, first of all, thanks for having me. Do you guys hear me? Yeah, that works. Thanks for having me. It's an interesting discussion, and I mainly can focus on the privacy issues because that's my main area. But the funny thing is that what the idea I got is that the discussion of high and low politics, we do have this here, even though we are actually in a state where you could say we do have policy. We have the GDPR, which is considered to be like a really high level privacy legislative act. And but I was just thinking about this right now. We have a big discussion in Germany whether on the political side, whether, for example, data protection is in way of fighting the pandemic, sorry. And even though we have rules set out there and we have clear statutes in place, and everyone could read up, what's allowed, what's not allowed, how to comply, and what are the standards you have to hold on things. And people still do go and say, well, we have too high standard of data protection, something we just established, and we're praising like 2 years ago all the politicians did then, and right now they kind of turn on it. So that's just the thoughts to the high and low politics. It's something that is, I think you will have it at any stage of discussion about the legislative process, even when it's done. Because the other thing I'd like to strengthen what I see if we're talking about trust and to lead to this, I think legislation can really do a lot in creating trust and keeping it with the consumers. However, it doesn't have to stop there. Well, it can't stop there, actually. You can't put out a great law which has all the things in it. The next thing you need to ensure is to set up actually an environment where it's going to be enforced by regulatory authorities and all those kinds of places who can really work. You can see this, for example, I just read something about Brazil. They kind of introduced a GDPR-like privacy legislation, but I talked to a guy over there, and he says, well, it's great. We have the greatest law here, but we have no authorities to enforce it. So, all the trust you kind of provide by a great legislation diminishes pretty soon again if people can't act on it or they don't feel that it helps them from a consumer standpoint. Maybe to leave it there for now.
Well, it's a perfect starting point. So looking at our clock here, I think we've got about half an hour, 35 minutes until we get to audience Q&A. So if it works for everybody, I'd like to spend 10 or so minutes on what I hear is kind of 3 areas that I think we've teed up here. I think the first one being Section 230 and content moderation, the second one being antitrust and competition policy, third one being privacy. So Jesse, I want to give you the unenviable task of, as you think about the concept of trust and what folks have teed up as concepts of trust and how to measure trust and how to enforce trust and all that sort of thing. How does that tee into the content moderation debate, or maybe to flip it around, what aspects of our debate around content moderation and governance here in the United States do you see sort of intersecting with trust? What specific legislative proposals are lurking out there? I guess I should say there's so many reform proposals about Section 230, it's sort of hard to keep track of them all. But what threads do you see in that legislative discussion that inflect with trust, and where do you see them going? And if you can tee it up, then I'll throw it up in the panel for jump ball reactions after that.
You only give me the easy ones, Blake. So here's why I started with the high and low politics framing is because I think this sort of tech as culture war, the performative aspects of a lot of these issues, 230 being a great example of it, have spillover effects into other issues and just deeply undermine trust, right? So a lot of my thinking here is informed by the work that Yuval Levin and others have done. Yuval regularly writes about how we used to have individuals who were molded by the institutions they were in, and we now have individuals who perform on top of the institutions that they serve in. And you can think of, it's easy to pick on Congress, so I'll pick on Congress as an example of an institution that has shifted where most of their members see their jobs as performing on top of the institutions. So here's how, the 230 debate and this sort of performative trust destroying impulse come together. There are lots of people, political leaders, political factions, civil society groups, whoever you want to sort of characterize as players in this debate, who are angry, right? Like the level of anger is very, very high. The things they are angry about are not just different, they are in deep tension with each other much of the time. So, an example I've written about in the past before is a hearing that Senator Cruz hosted last year, maybe it was the year before a subcommittee of the Senate Judiciary Committee. And this was one of those call in a bunch of executives and yell at them hearings. And Senator Cruz's opening statement was something to the effect of, you all are biased against conservatives. You aren't of my tribe, is effectively what he was saying. And so I don't.
And if I could just interject, Jesse, and ask if Amy or someone who's tending the chat can find the postcard that was circulated for this hearing, which is framed literally as a professional wrestling match. And I think Ted Cruz was the free speech champion, and Jack Dorsey was the czar of censorship or something like that. Sorry, go on.
No, it's like a metaphor sprung to life. So the opening statement was something to the effect of, I don't know if it's antitrust or 230 or privacy or an FTC, unfair and deceptive trade practices claim, but you all are bad. You need to take down less speech, and we're coming at you. And then Mazie Hirono, the Democrat from Hawaii, who was the ranking member, basically started her opening statement by saying, I don't understand why there's so much awful stuff on the internet. There's Nazis, there's election misinformation, there's vaccine misinformation, there's all sorts of terrible stuff. You all need to take more stuff down. It can be true that both factions, as represented by those two members of Congress, are angry, but if one is saying there's way too much stuff coming down and one is saying not enough stuff is coming down, it's harder to see compromise in there. And Blake, you're right, I'm not going to go through every legislative proposal. I think, to my mind, there are two types of proposals around Section 230 that we might see movement on, though I should be clear to say I have substantive problems with both of these sort of types of proposals. The first is around politically toxic subjects, right? So a couple of years ago, it was SESTA FOSTA and sex workers. More recently, it was a bill introduced by Senator Graham to combat child sexual abuse material, like just really the worst things on the internet. And the problem is not that they are wrong in identifying problems. It's that their solutions often have unintended consequences. So, it's possible as a political matter, even with a very hot topic, to see some coalescing around that. But what you tend to get are really blunt, overly broad instruments that do other sort of related harm. The second type of area where you might see some agreement are process issues. So I think of the PACT Act in this category. This is the bill by Senator Schatz and Thune. I won't go through the whole bill, but one way to read the bill, one way I read the bill is people are upset that they can't pick up the phone and complain to a tech company who's moderating their speech and force them to answer. And this is a way legislatively to say, please stop calling my congressional office and complain. And I'm going to compel companies to set up 800 numbers and reply within an artificially tight timeline and follow a sort of prescribed process around that. And so you don't actually have to come to agreement on the underlying what you're mad about in order to redirect the anger somewhere else.
So Gabrielle, I want to invite you in on this one. So what are your thoughts about the conception of the debate around content moderation, where there's obviously, or at least has been framed in Congress as being rooted from different sides of the aisle as mistrust in tech companies? What are your thoughts on that? And what are your thoughts about Jesse's framing of, we've got substantive issues, we've got procedural issues, and it's tough to reach compromise, especially in the former category. Do you see us actually getting somewhere productive with this debate over the next couple of years?
Yeah, so I think first, just reframing the way that Color of Change looks at misinformation, which is where we tried to enter the 230 debate. And how platforms can address misinformation is not necessarily through Section 230, but instead looking at misinformation and content moderation as an exercise and abuse of platform dominance. When you look at the terms of services of like Facebook and Twitter, a lot of the things we're concerned about on their platform falls into existing terms of services. So when you think about like misinformation around the COVID pandemic, they have policies saying that that's not allowed. But when you have folks coming forward and saying like, hey, this is misinformation and it's deadly misinformation, it's going to mislead people to think that this is a solution to the pandemic when that's not proven. You see a lot of times that they're slow to act. And part of that is because there is not competition. There's not another social media platform that is as big as a Facebook or Twitter, where folks can say, hey, this third platform there's no misinformation on this platform, so let's all leave Facebook and go to this other platform instead. We don't see government action in terms of, enforcing those antitrust laws. So that way we see that, that competition. Unfortunately, the platforms are so big that even when you have a Stop Hate for Profit ad boycott that was led by Color of Change, where you had hundreds or thousands of advertisers say that they're not going to advertise on Facebook anymore because they don't want their ads running alongside, white nationalist militias and their posts online. Mark Zuckerberg can tell their investors not to worry because they know that they're part of an ad duopoly and that those advertisers will have to come back. And so we're looking at how we can use antitrust laws to sort of like create more competition in the market, how we're looking at algorithmic amplification and how optimization algorithms and the business incentives of leaving posts that get a lot of engagement up online, even if they may be promoting misinformation, trying to look at other levers to address these issues. For Color of Change, we're not really interested in 230 reform bills unless they are making it explicit that civil rights laws apply online. Thinking in particular about the Facebook defense when they were charged with violating fair housing laws, when advertisers were able to exclude Black renters and Jewish renters from seeing housing ads. Facebook told the court that 230 protects them from complying with the Fair Housing Act, which obviously is not true. So we'd like for there to be legislation that makes that very clear, so that way Facebook doesn't even have the opportunity to bring a claim like that forward. So for those reasons, we're not as interested in the Earn It Act. We're still taking a look at the PACT Act to see, because we're interested in data disclosures, to make sure that way that federal regulators can follow up with Facebook when they say that they are taking down posts about hate speech and things of that nature, to make sure that there is then follow up to make sure that there is compliance. So that's sort of like where we land on those two bills.
Perfect. So I'm going to acknowledge Amy kicking me under the virtual table here. We probably should have started this discussion with 30 seconds on exactly what we meant by Section 230, since we've been diving into the weeds of the proposals. But just as a backfill for folks who are not familiar, this is the law that basically provides immunity for a wide array of internet platforms for being held liable as the publisher or the speaker of information that's posted by others on their platform. And so one thing I heard in Gabrielle's answer is, to what extent, and maybe this is a point in common with what Jesse had to say, is to what extent can platforms actually be held accountable? Are the problems that we are concerned about the kinds of problems that Section 230 actually gets in the way of solving? And Gabrielle identified some where I think there are civil rights and thinking about transparency. Jesse talked about the PACT Act, kind of brings up transparency as a potential place for reforming Section 230. Okay, so we've got Section 230. We've got a pretty fractious debate. We've got lots and lots of proposals, but we'll leave that for the moment. I want to transition us to talk about antitrust. Gabrielle teed us up there. So Marianella, I wonder if I could lean on you to give us an overview of what's lurking out there, particularly in the United States, but to the extent you also want to give a little bit more explanation on what's happening in European proposals and how that relates to trust. In other words, when we think about going after the competitive aspects of how big tech companies operate, how does that intersect with the themes of trust that we've discussed throughout the rest of this conference?
Sure. So I think we can discuss trust from many perspectives, and to be one of the most interesting one is what Gabrielle mentioned earlier regarding discrimination and AI is going to be one of the hardest topics to solve in the future ahead. But with respect to antitrust, I would say that it's important to be able to have a market economy. You need to have trusting institutions and make sure that the laws that those institutions are enforcing work well for consumers. And I think in the last years, there's been a lot of discussions around whether antitrust is fit for purpose in light of the digital economy. And many of those discussions have, I would say successfully, managed to mingle a lot of topics that don't pertain to antitrust in the antitrust discussion. And I'm not very sure that has been helpful for the antitrust debate. So to me, when we talk about antitrust, we really need to focus on the market and whether they are working well by enhancing the consumer welfare and ensuring that innovation is not stopped. I'm not saying that other topics are not important. I think privacy, consumer protection, non-discrimination, environment, any of other policies that you might think about are super important, but they shouldn't be factoring into the antitrust discussion or analysis. Why? Because then we will risk making antitrust very permeable to politics. We don't want to have a market economy where politicians or powerful stakeholders can influence the market. So in a way, what I think it's one of the misunderstandings about the tech industry is that we discussed, and this was mentioned earlier this morning as well, that the US has a problem with market concentration. And from a macroeconomic perspective, that might be true. I'm not saying it is or not. I don't have the data, but that might be true. Some sectors like airlines, like sectors might be concentrated, but when you take the antitrust norms and you see how they have to be enforced and how the authorities have been enforcing the laws throughout for the past 100 years, they look into them in a way, to say so, in the microeconomics, whether a particular sector defined based on rules that the judges have defined work or not. And if we look at the tech sector, we tend to think about, okay, Facebook doesn't have a competitor, or Google is just search, and Amazon is just a retail. But when you take it from an antitrust perspective, you see that the tech sector is incredibly dynamic, and all of these big are present in many, many, many markets. They compete against each other. And that's the antitrust angle to it, which is not very populist. And fortunately, it's hard because it's boring. I mean, it's hard to put out this debate. And it's easier to say, you know, the markets are concentrated. Look at tech. There are only 5 big platforms. There are no alternatives, and antitrust is not working. And I just think that's a simplification of what the antitrust norms have been used for in the US and abroad. And if we, when thinking about regulating trust, and in this case, the trust in the markets, if we don't surpass that debate that is being in the headlines for the past 2 to 3 years, and we don't enter into policy rather than just politics of what sells more, we risk harming a system that, with all its flaws, is been working well. Even so, for the US, where it has created an innovating ecosystem like in nowhere else. So that concerns me a little bit. And I think making an effort to make sure that we respond to the right questions that we want a regulation to tackle, and then giving enforcers the right human resources to be able to enforce those laws is the equation that we should follow. And to that end, we should respond to questions like competition with competitiveness, for example, or competition drives innovation, or innovation drives competition in the digital sector. There are many questions that haven't received a response yet, which should start forming part of the debate, I would say.
Thanks, Marianela. So Gabrielle and Jesse, welcome you back in for some quick reactions here. So Marianela mentioned this concept of consumer welfare and the idea that for many decades in the United States, we've focused our antitrust inquiry on basically impacts on consumers as measured by the price of products and and services, and that we're now seeing lots of reform proposals that aim to have a broader role for antitrust, that look at harms that can be caused by services that are sold to consumers for free or without cost, or that measure things other than just pure impacts on price. And those are present in the House Antitrust Subcommittee released a report that recommends some changes in this vein. Senator Klobuchar has got a proposal out that recommends some changes in this vein. Curious for quick reactions from both of you before we shift over to Jeff and Dirk to talk about privacy.
I'll jump in really quickly to say that there is some work that needs to be done in promoting small business, the growth of small businesses. When small business owners have to go to a Facebook, if they're an app, we saw with Vine, when Facebook took away their access to API, the app died. And so it may not necessarily, so we have to look at the way that dominance is being used. We may not agree that Facebook is a monopoly, but we have to look at the effects on the market and have to acknowledge that there need to be some guardrails put in place, so that way that we can see more competition thriving, where we don't have to worry about folks who are on the Amazon or the Apple marketplace and worrying about the 30% cut that they have to give just to run their business. There needs to be some or better protections in place for sure.
Jesse, offer you a quick chime in, and then Dirk offered to come in on the international perspective here.
Yeah, a real caution, and I think Commissioner Wilson talked about it this morning quite effectively. There's a real risk in us moving away from a question of what is good for consumers or not, and towards a question of which company do we want to win in a market. Because when you get into a situation, and she warned about this, where regulators are picking winners and losers in particular markets. I like this business, I don't like that business. I wish these business terms were changed in this way as opposed to that way. That is divorced from a clear measure of success. The measure of success we've historically used is what's good for American consumers or not. Then you empower regulators to reward friends and punish enemies. One very brief story to illustrate this. President Johnson used antitrust power pretty effectively to curry favor in his re-election campaign. The owner of the Houston Chronicle at the time was also the owner of a major bank. And that bank had a merger that was before the Justice Department. Now, the Houston Chronicle in its history had never endorsed a Democrat for president. And lo and behold, he had a major merger, and President Johnson called up the owner of the paper and the bank and said, "You have a merger before us. I would really like your support in the upcoming election." And lo and behold, in the only instance at the time of the paper sort of crossing aisles, as you will, the Chronicle endorsed Johnson's reelection in '64. And that's not an isolated incident. I think from the advent of antitrust laws through the first several decades of their implementation in the United States, the history is just sort of rife with politicians picking winners and losers. I like this firm, I like that firm. And so I think we should be really cautious about saying we want to allow politicians to sort of dictate the winners and put a veil of competition language on top of that.
Okay, so in U.S. law, we're having this sort of long-running debate about how to balance the concerns of antitrust law not having moorings to which it can be attached, which we've found in economics for the last couple of decades, and the potential for abuse for political purposes, against the sense that it might not work well enough for the sort of companies of today, or the tech companies of today, that it relies on metrics that don't work for that. Dirk, can you come in and give us a handle on how the European experience differs from the U.S. experience on this?
I don't know if it differs really that much, but what we found out is that well, maybe we're one step ahead on discovering that it's not an issue of antitrust on the one hand, privacy on the other hand, and Section 230 again on this side, but it all kind of mingles together in a way, because that's what I wanted to say. We just had in, I think it was 2019, we had a big decision by our Federal Antitrust Authority against Facebook, which prohibited Facebook to combine data from its daughter companies like WhatsApp and Instagram and build profiles on it. And Facebook went to court against this, and after all that, there's been an interim relief decision by the Constitutional Court, even in Germany, and they kind of said, well, the antitrust authority was right, so Facebook has to deal with this right now. But what I want to say is that it's not about the pure question of money anymore, but it's also the question of data power, and recognizing that data power actually has an enormous economic value for those companies. So I think that's something we see that, especially from the enforcement perspective, I take from our authority, we have a lot more interaction with those different areas of law, like antitrust law, competition law, and we do find that there is a lot of overlapping actually, which kind of, from my view, leads us to better situation for the consumers, you know, because sometimes all those, it's still the big tech companies, that's what we still call them, because that's what they are, and not only, you know, to the size, but you have those small enforcement authorities, European, there on this against the big Goliath, and yeah, if you kind of combine this, you can reach and achieve more for consumers, in our view.
So really appreciate the notion that these topics are intertwined. And Jeff, you've been terribly patient here. So I want to bring you in to talk about privacy. So there's an antitrust, or actually a pair of antitrust lawsuits pending against Facebook here in the United States, one from the Federal Trade Commission, one from most state attorneys general. And one question that lies at the end of that antitrust lawsuit is, what remedies come about? Do we wind up breaking up Facebook into constituent parts? Do we wind up having some sort of interoperability standard? And replete in all of those questions about antitrust remedies are questions about what data privacy law is going to do, or what privacy and data protection law, which I suppose we could consider separate concepts, are going to do. And so antitrust is going to run headlong into this long-running conversation about U.S. privacy legislation. So Jeff, what's going on with U.S. privacy legislation? Where are we going to head with this? And I have to disclose before we get into this, Amy Stepanovich and I have a bet about whether there's going to be federal data privacy legislation in the U.S. this year. I have money on it not happening, and I have to not tweet for a month if we get it done before January. So tell me, am I going to be kicked off of Twitter come January?
You had just tipped your hand. I was going to say, when Amy and I first spoke about my participating on the panel, now I understand why she wanted me to come on and talk about why privacy legislation was going to get accomplished this year. I was really struck listening to the first panel this morning when Attorney General Weiser and FTC Commissioner Wilson both decried the failure of Congress to act. And it was very striking to me that Commissioner Wilson was saying it's federal legislation is a first order solution, but the FTC is prepared to move forward, and she appears to be ready to support moving forward with what she described as a third order solution. But it was, in her view, as I understood it, it's better than nothing. We've waited long enough. And so when you have a commissioner like her ready to join Democratic colleagues and potentially moving forward, I think that's a signal to folks on Capitol Hill that either they're going to set the rules, or as they like to refer to them, unelected bureaucrats are going to set the rules. I think there is, as I said, broad consensus in the Congress now, with really only two major issues to be resolved. If you look at the lineup of the members who care, you look at the last Congress, you had three major bills in the Senate. One supported by Jerry Moran of Kansas, another by then Chairman Roger Wicker of Mississippi, with four other Republicans, including John Thune. And you had a bill put forward by the Democrats led by Senator Maria Cantwell, who, by the way, became the first female chairman of the Commerce Committee in 200 years yesterday. And somebody who understands tech. For those of you who don't know, she was a Real Networks executive back decades ago, so she understands tech. If you look at what those three bills have in common, and I looked at a quick list: right to access, right to correct, right to delete, right to portability, right to opt out of all our specific processing. You take 20-some issues. Each of them has a provision on that subject. There are only two big gaps where they are fundamentally at odds. Federal preemption. Democrats, of course, do not want to preempt California. And now you've got Virginia. And you'll have other states if Congress doesn't do anything. And Republicans who don't want to give what they see as Democratic trial lawyers a private right of action to enforce a federal law. I think there is room for finding common ground there. I think the tech industry, which has worked hard to find common ground, has an even greater incentive to find common ground now, because we're going to be looking at the prospect of 50 state laws if we don't get a federal law, and that means compromise. But if you're a Republican, you can find compromise, I think, on private right of action as well. The House, I think, is also primed to move forward. The chairman of the Energy and Commerce Committee in the last couple of days has said this is a priority. And again, one of the reasons I think something could be done gets back to the point I made in response to Jesse's opening is, I think this is a debate that can occur at the technical level. Yes, the two issues that remain are highly political, but we're talking mostly technical issues. What's the right way to help consumers? What's the right way to protect their data? And one thing to keep in mind that I always keep in mind when I think about a problem on the Hill and think about lobbying, it is remember that staff and members are affected by these laws. They have devices. They share the same concerns we do about where is our data going? How's it being used? How can I see who's doing what with my data? And that will help drive the debate because it affects them directly in ways that we sometimes forget. Sometimes these issues are esoteric, but these issues affect them directly. They have a personal stake in getting it done. And after 20 some years, there's nothing really left to debate. It's just a matter of finding common ground and getting it done.
So I want to give the panel a quick chance for reactions before we turn to students. And before I do that, I'll say if folks have questions, you can feel free to pop them in the Q&A, and we'll surface them here in just a second. But before we do that, Dirk, maybe I'll call on you. There's obviously Europe is a little bit further ahead than the U.S. and is already kind of living the experience of what it looks like to have serious privacy constructs. What should we expect as we look a couple of years down the line, based on the European experience?
Well, it kind of depends on what you're trying to achieve, to which level you want to come. I mean, I looked at the California Consumer Privacy Act, and some things even there are going beyond what's in the GDPR and in certain areas. And in other areas, people aren't that advanced as we are. So I think it will be a different situation also from the historical background. And I think in Europe we have a much more, I think, I don't know who it was in one of the earlier panels, they talked about, about why data protection and privacy is such an important thing for Germans, especially if we're looking to the background of the Stasi, especially Eastern Germany, and secret policing and everything like this. So I think that's also something cultural, which you have to look at and to define where you're gonna end up. But one thing is what I found out from 2 years into using the GDPR, there are a lot of things in the details you don't see. I was involved in creating the GDPR. I pitched in a little on some things, and there were things, especially if we're talking to the one-stop shop and all those kind of things where we found out in the practical life, it kind of turned out different than we expected. Things don't run as smoothly as they supposed to. So I think such a legislation is not done when it's done, but it's a process, especially if you're coming from close to nothing. You will have to find out that it's much more than giving people rights, to get information about and delete data and interoperability. But there's a lot of details and twists in the how to work with the legislation in the end.
So for the students in the audience, perhaps an area in which there might be a tiny bit of legal work available over the next couple of years. Gabrielle, go to you, and then to Jesse for the final word, and then we'll turn to Q&A.
Yeah, I really want to touch on just like a different way of looking at privacy legislation. So instead of taking an opt-in, opt-out model, which all of the bills that Jeff mentioned that's the approach that they take to privacy legislation. I do want to uplift Senator Brown's discussion draft. I think it's called the Data Act, but I cannot remember. It takes a permissible prohibited framework where instead of putting the onus on consumers to tell Facebook or whatever company that has access to our data, I'm telling you, yes, it's okay to use my data as you see fit. A prohibited permissible standard would say that there are certain uses of my data that are unacceptable. And we see the chief of that is discrimination. Privacy is the cure to surveillance, and communities of color and other historically marginalized communities are disproportionately impacted by surveillance. And so we need a privacy bill that centers those civil rights protections, so that way we do not find ourselves 20 years from now wondering why, when we had the chance of putting a privacy bill in place, making sure that those communities were protected.
Jesse, go to you for the last word.
Sure. So I think Jeff is absolutely right on the substance. Where I disagree is on the politics, or at least the realm of the politics. And I should say, my colleagues at Americans for Prosperity support federal privacy legislation. We've written about it. Happy to go into the details. A lot of that maps onto the sort of outline that Jeff gave. But that requires finding 60 votes in the Senate and not having 41 votes who want to stick it to an actor or a stereotype of an actor that they dislike, and not wanting to weaponize this issue. And I think, quite frankly, that's just really hard. There are some structural differences with Europe, and I appreciate Dirk's description, but you can get away with writing relatively vague laws with a sort of come and talk to us later because we're only really targeting a few companies structure in Europe that you can't get away with in the United States, in large part because you don't have the class action lawsuit problem in Europe to nearly the same degree that you have in the United States. And so private rights of action aren't the sticking point that they have been here. It's not accidental that they've been a sticking point, and I suspect that'll remain. The last thing I'll say here is, what is clear from this conversation, I think Dirk alluded to this earlier, is there are real tensions between these issues, right? So you have many of the same members who say, we are really upset about bigness and power, and we think antitrust is the tool, who are also the same members who say, we're really concerned about privacy. And so we want to mandate interoperability, or we want to mandate restrictive privacy laws. Well, if one of the solutions you're going to offer on the competition side is data portability, and on the privacy side, you're saying lock everything down, those things are in tension. So maybe the lesson for CU students is it's a great time to be a privacy lawyer, or quite frankly, a great time to be an antitrust lawyer. But I'm a little more skeptical about the prospect of something moving in Congress.
Well, speaking of, sorry, go ahead, Jeff.
Just say one thing to answer Jesse there. The premise of my assumption is that you would have a bipartisan bill coming out of the Senate Commerce Committee. And if you had a bill supported by the Democratic and Republican leadership of the committee, you will get 60 votes. If it's a one party only, there's no chance of the legislation passing. So this does depend on the leadership of the committee coming together behind a single bill, which their members will support.
It's a well taken point. I just remember, last year and the year before, every month we'd hear the bill is coming. The bill's coming in April. The bill's coming in June. The bill's coming by Labor Day. Labor Day ended up being defined as something in November. The bill's coming at the end of the year. And, there's a bit of a boy who cried wolf element to the congressional negotiations.
As long as the bill comes in January of 2022 or later, I will be happy.
Your Twitter account's safe, I think.
Well, Jesse, you mentioned CU students, and as has been the case through the rest of the conference, we'll follow the Silicon Flatirons tradition of giving the first question to a CU student, and that student is Alan Harrison. Alan, welcome, and feel free to jump on and throw in your question.
Hi, good afternoon. As Blake mentioned, I'm a first year at Colorado Law. I also worked at the Hill and come from DC, so that's my background anyway. So because of that background, my question is piggybacking a little off some of the themes that Jesse and Gabrielle mentioned. From a political standpoint, we're trying to get to a consensus and something that actually passes rather than necessarily like what's the legal, bill of privacy rights, as it were. And then from sort of Gabrielle's perspective, like how do you get citizens to actually feel that they trust companies? So my question is, where is the quickest route to getting consent to a solution that makes people feel that they can say, I trust company X to act? Is it legislation that focuses on empowerment of individuals, so opt-in, opt-out, they have redress programs for companies, or is it focused on the other end at the actions that companies take and limiting what they do so that the consumer has a very hands-off approach?
Gabrielle, I see you nodding, so I'll invite you to take this one first and then go to Jesse and then any other follow-ups after that.
Yeah, I think it's the latter. I think it is restricting what companies can do. So that way consumers don't have to have a law degree and be able to read terms of services to see like what their data is going to be used. When you think of the working American, they don't have time to read all the terms of services of all of the apps that are on their phone or that they may come in contact with when they walk into a store, for instance. We don't think about the different technology that may be collecting data when you check out at a grocery store and things of that nature. And so I think that that's the way to instill trust. So that way there isn't this burden of, did I understand that correctly? Like, did I miss something? And making sure that in addition to that, I want to also uplift something that Dirk said. We need strong enforcement. So we need to make sure that there is an agency at the federal government that is also following up with these companies and making sure that they're doing what they say that they're doing, but also that they're following the laws that are on the books.
So I think it's a really great question, Alan. I'll say two things in response, one of which kind of fights with the premise of the question. So the one that sort of more directly answers your question, I'll defer to my colleague, Neil Chilson here, who was an attorney advisor and the acting chief technologist at the FTC. And Neil wrote a paper that I'll drop in the chat called When Considering Federal Privacy Legislation, that I think wrestles at a values level with a lot of the things that Jeff and Gabrielle and others have talked about as being in legislation. And so that's a helpful frame for me in thinking about what might be in federal legislation. To argue with the premise of the question a bit, I wouldn't rely on legislation here. I think there are meaningful things that are being done right now to improve both consumers' knowledge about what privacy choices they have, to Gabrielle's point, and real that are enforceable both by private actors and by public actors, right? So the obvious example that comes to mind are the privacy nutrition labels that Apple's rolling out for apps in its app store. But you can also think about efforts like Google's privacy sandbox and movement away from cookies. There are real changes that are being led by individual firms, by consortia of firms in the private sector that, quite frankly, are going to outpace anything that happens on the policy front. And so that's where I turn to for sort of real progress on governing privacy.
Jeff, I feel like I need to invite you in here. You might have a differing.
It was a good question, Alan. The private sector will solve the problem well before Congress does. Congress is generally well behind in getting something done. As Jesse was speaking before I even mentioned it, I was thinking of the fight emerging between Apple and Facebook. That's what consumers pay attention to. If you have an Apple device, you're paying attention to that now. You're not paying attention to whether Maria Cantwell is chairman of the committee or whether John Thune is going to work with her or some other Republicans to produce a bill. The legislation is important because it sets the rules that dictate how the game can be played. But in the end, it's up to companies to generate trust, to give people a reason to say, if I have a choice, I'm going with you as opposed to the other entity.
So, want to turn to a question from the Q&A, and this one comes from Callie Schrader, who's a former Colorado law student. So we'll keep the tradition. Callie, raise your hand if you want to jump in and ask this yourself, but otherwise I'm going to read it. So Callie asked a question about a theme that's come up several times in this conversation, which is how do we do enforcement, and what do the details look like on enforcement? And so Callie's question is, how can we identify the distinction between when enforcers are picking winners and losers versus when they are enforcing rules based on bad practices that they have become aware of because of company action? So there's a possibility that both of these things can look like picking on a company, but the motivation might be distinct. And sometimes we might even see that, we might even debate which of those things is happening within a particular enforcement action. I'm thinking in particular about some of the antitrust enforcement actions during the last 4 or so years, which were sort of created some odd political bedfellows in terms of who was supporting them, who was worrying about them being politically motivated, and that sort of thing. So jump ball to the panel on this question about how do we calibrate enforcement without the appearance of picking winners and losers. Dirk,
well, maybe I could join in from a regulator's perspective. If you have the law set up and you have the rules there, then what you would need is an independent supervisory authority, regulatory authority who can act as such, who's independent from lawmakers, who's independent from the executive branch, from the government. That's how we are set up at the federal commissioner supposed to be set up, and that gives us the trust that we act upon, to fulfill the law and to work towards compliance for the beneficiary of the consumers. I think that's an important thing. Of course, you will have problems whenever you have a law set up that might be biased or view biased to strengthen or weaken especially certain actors. But once you got this set up with a good law, then you need independent authorities who can do this. And that's obviously from the European perspective, without all the class action things. I agree with Jesse. That's a main difference. But if you can get past this, then actually you can work with you have to staff those authorities, and then this question wouldn't arise, I think.
Jeff, want to invite you in on this one. Do you see any particular dimensions of selective enforcement and how that works playing out in the contours of the privacy legislation debates?
Not really, but I was struck again listening to Commissioner Wilson this morning talking about this very issue and a concern on her part that they not be seen to be picking winners and losers, and simply if you focus on consumer welfare, for example, under her organic statute, and you trust your regulators, you can get good results. But there is the risk that a regulator may have something in for a particular company, but in my experience, they tend to play it pretty straight and act as umpires rather than players on the field picking a particular side to win.
Marianella, I turn to you.
Sure. So I think it's a very complicated question, and actually a very pertinent one with what we're seeing more internationally than just locally. And I think it's easier to identify selective regulatory proposals than selective enforcement, because at the end of the day, authorities operate under they just enforce the laws if they receive a lawsuit or they justify the law. There's a process. This is particularly the case in the US, where, for example, in antitrust, you have two agencies. You have the FTC as an independent agency and DOJ. The difference between them and having both of them, it's a very unique aspect of the US antitrust system, but it really makes a difference in the sense that at the White House, the president can call the antitrust section of DOJ and say, if you don't go after this company, you're fired. And if he says no, he will have to say, yes, sir, I'm leaving tomorrow, hang up. Where the FTC wouldn't have to do so because they are independent, more independent. I'm not saying DOJ is not independent. What I'm saying is the institutional design with two heads in the US for antitrust enforcement, it does give some guarantees that there's not going to be selective enforcement, and plus it's a judicial system, so you'll have to litigate upfront. You don't have a decision and then you litigate upfront, and that gives more security. I wouldn't say that there is selective enforcement in other jurisdictions. What I do think is that companies take advantage of the fact that some jurisdictions are more prone to go against certain practices, and they just do forum shopping as it has always been done, but not only in antitrust, but in other fields of law. But I don't think enforcers, I do think enforcers enforce their laws in non-discriminatory matter. It's just as an end result, you can have or seem to have enforcement discrimination if you wish, but not necessarily because the enforcers decided to do so, but because the circumstances led to that consequence.
Well, on that note, keeping an eye on the clock, I see we're right at about 1:15. I have to congratulate the panel. I didn't think we were going to fix it all in 75 minutes, but I think we did. I think the path is clear here. In all seriousness, thank you to y'all for leading us through a complicated tangle of all of the different laws that intersect with trust, and giving us a preview of what we might see and how we ought to think about what's going to happen over the coming months and years. Really appreciate y'all. I will at this point hand things over to Victoria, who's going to introduce I think our closing keynote. Thanks, everyone. Have a great afternoon.